As CEO of the company, I accept responsibility for Enron's collapse, as I've said before. However, that does not mean I knew everything that happened at Enron.
Remember him? That was Ken Lay, the founder of Enron. For a time, not too long ago, it seemed like all we heard about was corporate fraud. Huge companies making headlines. Tyco, WorldCom, cable giant Adelphia, and even bigger names, Martha Stewart. But now the mother of all white-collar crimes is about to take center stage. When Enron founder Ken Lay stands on trial on multiple charges, including conspiracy and fraud, at his indictment in July, Lay asked for it to be over quickly.
I have instructed my legal team that I want a speedy trial, and I hope it will begin by early September this year.
But that was nearly 6 months ago, and still no trial date has been set, so what's taking so long? My take? The trial of Ken Lay is the legal story for 2005. It is the one to watch, and the result is anything but certain. Joining us now, Charles Gasparino, senior writer for Newsweek and author of the soon-to-be-released Blood on the Street. Gerald Lefcourt, criminal defense attorney, and Christopher Bebel, a securities law expert and former federal prosecutor. Charles Gasparino, let me start with you. You and I began with the day of the indictment back in July, and I don't think it's a slam dunk. I didn't think so then. Anything change from now to then?
No, you know, it's definitely not a slam dunk. Listen, you have to prove criminal intent, and that's very hard in these white-collar crime cases. But on the other side of the coin, the public really is in no mood for the Ken Lays of the world. I mean, he, as you just saw in the clip, he basically gave us the Sergeant Schultz defense. You know, I don't know anything. I may be the chairman of the company, but I didn't know what was going on. I don't know if the public's really going to buy that. Now, this is going to be an interesting case.
Indeed it is. Christopher Bebel, when you look at this whole idea of trying to get inside the mind of someone like Kenneth Lay in order to prove what was going on, one of the problems I think the prosecution has here is this is a man, unbelievable as it may seem, who didn't use a lot of email. Think they can prove this?
Well, it's going to be tougher for the government to prove up its case because it's going to be hard to connect him to the evidence that showed what was actually going on inside the company. That absence of email will allow him to position himself as someone who was out of the loop, who was kept in the dark, and who was acting in good faith.
Jerry Lefcourt, we starting to sound like this might be an easy case, and of course it's not. You have tried many of these cases on the defense side. Isn't the hardest thing here the fact that Enron is a name that almost makes you vibrate, especially in Texas?
You know, the defense conducted a survey of potential jurors in Texas, and many of the jurors, perhaps a third, called the defendants in this case, that's Lay and Skilling, snakes, pigs, terrorists, economic terrorists. This is a very dangerous atmosphere, particularly for an innocent executive. I mean, it's really, you know, for those that are guilty and they have evidence, fine. But for somebody who really deserves the benefit of our constitutional system and a reasonable doubt, this is a very difficult atmosphere to get a fair trial. And what Ken Lay did was say, yeah, I want a quick trial right now without a jury by myself, and I will let the judge decide whether I'm guilty or not. They wouldn't give him that. They want a jury. And so what's going on, he's not going to be tried by himself. He's being tried with co-defendants who there's much more evidence against, and that's why it's going to take so long.
Well, indeed. And Charles Gasparino, right. One of the aspects of this case is, of course, it's the building blocks that the government has done. They have gone up the chain.
Right.
And they haven't gone all the way to the top. So we have Mr. Lay there along with Mr. Skilling.
Right.
And we're at a point where those two people really being at the top still have to kind of rise and fall together, or am I wrong?
No, I mean, listen, they're joined at the hip in some ways because they both essentially have the same defense, that they didn't know what was going on. This guy Fastow, the CFO, Ken Fastow, designed this whole kind of sham accounting system that showed Enron's profits over the years. I mean, that's the basis of their defense. But you know, the gentleman just before me made a great point. Juries really have no patience for people in corporate America right now, especially anybody accused of wrongdoing. I mean, listen, I get tons of email from people still. Listen, there's a tsunami that just wiped out 100,000 people, and people still talk about the corporate scandals. So this is a very difficult time to be a defendant in one of these cases.
Indeed so. And if I can go back to Mr. Bebel, if I may, only because of dealing with where you are in Houston. Is there any way for him to get a fair trial there?
Well, on the record, on the face of things, it will appear to the appellate court, assuming convictions are entered, that a fair trial was received, because those jurors are going to state point blank and very convincingly that they can be fair and impartial. The judge is going to protect the record in that respect, and it's going to be difficult for an appellate court to override the jurors' own statements and disregard them while coming to the conclusion that this was a biased jury.
Jerry Lefcourt, if I can switch topics very quickly to Martha Stewart. She's been in jail. She certainly says she's pursuing her appeal. Appellate judges have got to consider the fact that she's already served a sentence.
You know, I think it cuts both ways. You know, I read her appellate brief today, and it's really strong. She's got really 4 good, strong points. But you're right, some judges might say, look, she's going to serve her time anyhow. It's over. Why give her a new trial? Others are going to look at these 4 points and say it doesn't matter that she served the time already. I mean, this is a woman who was the head of a company. She can't be the head of a company, a public company, with a criminal conviction. She can't hold the positions she held on the New York Stock Exchange. She can't do any of those things. And so they're going to look at these points and say, you know, if they're right, then she's entitled to a new trial. But the worst thing about it is if she's correct on any one of these points, all we do is get another Martha Stewart trial.
All right, and the last word to you, Charles Gasparino. I only have a few seconds left. Is she a winner in the end, or is she a loser?
I think Martha Stewart's a loser. Listen, she's as guilty as they come. I covered this case from the beginning. That was a very strong case. I believe her company is in deep, deep trouble. One of the reasons why it's in deep, deep trouble, even though the stock is going up lately, and don't ask me to explain why that is, but even though this is a company that she dragged down with herself because she just didn't admit that she did something wrong from the beginning.
The stock is going up, Ricky, because this country not only loves to destroy the rich and famous, but we love to rehabilitate them as well.
That's baloney.
Yeah, well,
don't buy the stock.
I'm not even going near there at this point in time. You guys are great. Charles Gasparino, Jerry Lefcourt, Christopher Bebel, thanks so much.